Ladies and gentlemen, today my interest is to talk about what we call the gravel. The gavel, most people do not know, is what they call the hammer. Some people use it as a hammer in court language, but ideally that's, that gavel, in light of versus the voice in terms of the legal implications of jailing a sitting president of Uganda Law Society. The recent sentencing, for example, of the Uganda Law Society President Isaac Ssemakadde to a 2-year imprisonment for contempt of court has actually sparked significant debate within the legal community and the broader perspective. Justice Musa Sekan, of course, of the High Court in Kampala, handed down the sentence, citing Ssemakadde's derogatory remarks on the social media, which were deemed to undermine the authority of the judiciary. And so I'd like to argue, in light of the context, but also in light of the legal implications of such an action. For starters, Ssemakadde's conviction centers on his public criticism of judicial decisions and specific judges, which the court obviously interpreted as contemptuous. And this case basically underscores a delicate balance between upholding dignity of the judiciary and protecting the fundamental rights of freedom of expression. While the judiciary, of course, must maintain its authority to command respect, it's equally important to ensure that individuals, including legal practitioners, can actually express dissenting opinions without fear of retribution. And that is something that is extremely important. First of all, let's contextualize our argument in terms of what they call historical parallels. This incident is not isolated as far as Uganda's legal history is concerned. Notably, the former Uganda Law Society President Sam Kenjuba was actually imprisoned for speaking out against rights violations of matters during his tenure, and he later reflected that in light of that he had no regrets of his actions, highlighting aspects to do with the tension between legal advocates and government authority. Now, if you argue in terms of broader perspectives or in terms of implications of the legal profession, the imprisonment of a sitting Uganda Law Society president raises concerns about the independence of the legal profession and the space available for lawyers to critique the judiciary, for example. And it prompts a critical examination of the boundaries of acceptance as far as discourse and the mechanisms through which the legal community can actually uphold the judicial accountable without crossing into any kind of contempt. And that is substantially important for us as jurists in this particular aspect. Now, while it is imperative to uphold the integrity of the judiciary, it's equally crucial to protect the rights of individuals to express dissenting views. Yes, and the legal community must actually navigate these complex dynamics to ensure that justice, for example, is served without compromising fundamental freedoms. And that is something that is extremely important, again, from the word go. Now, also, if we're to argue in terms of legal and judicial consequences in terms of imprisoning or a sitting Uganda Law Society president, the imprisonment, for example, of Isaac Ssemakadde, the sitting president of Uganda Law Society, for contempt of court has actually profound legal and judicial constitutional implications in light of what has just occurred. And these are some of the things I would like to shed light upon. If we are to begin, for example, in light of what they call legal consequences, for example, in light of what? In light of the aspect of loss of office, the Uganda Law Society Constitution and governing statutes may have provisions regarding to the impeachment or removal of a sitting president if they are convicted of a criminal offense. However, the contempt of court is not necessarily a criminal offense in the traditional sense. It is what they call a quasi-criminal proceeding, and that is something you must understand from the word go. Please contextualize and understand that from the word go. Now, the impact of professional standing, the Law Council, obviously, and the Uganda Law Society Disciplinary Committee may assess whether the conviction affects Ssemakadde's standing as an advocate. And if it is deemed to undermine the integrity of the legal profession, he could actually face temporary suspension or even disbarment from practice. That is something, again, we must understand from the word go. Now, in light of precedent from other lawyers, the case obviously sets a dangerous precedent where lawyers, for example, especially those who are outspoken against judicial decisions, for example, could be subjected to contempt charges as a means of silencing dissent. And this could create a chilling effect on the free speech within the legal fraternity. That is something, again, we will have to think about in light of what has just happened. In light of perhaps what you'd argue in terms of judicial consequences, we could argue that the erosion, perhaps the erosion of the judicial independence, if the judiciary is, for example, perceived as using contempt proceeding to silence, for example, criticism, it, for example, risks certain aspects in terms of impartiality, and that causes substantive issues. Now, increased scrutiny, for example, in this case, could actually spark constitutional challenges in terms of broader and even sometimes, vague or even court interpretation when it comes to the issue of legal reforms or judicial clarification in terms of this particular content, as I was making the case. Now, there could also be aspect of potential backlash in terms of international legal bodies, human rights, or organizations which may view this as a violation of freedom of expression and the right to critique judicial decisions in the context of what we're arguing today. And that is something, again, that's extremely important that we need to understand as well as far as this issue is concerned. Now, what options, for example, does Ssemakadde have? One of the things is perhaps appeal in light of the conviction, and that's one option for him that he could look at. He can file an appeal in a higher court, for example, a court of appeal or Supreme Court, for example, challenging the ruling on grounds of procedural irregularities. Yeah, for example, in terms of excessive sentencing, or even in terms of violation of constitutional rights such as free speech. That is something that could also be, a card for him to pull out in light of that context. But we could also look at seeking constitutional interpretation in terms of contextualizing it in terms of constitutional interpretation, for example. Yes, he can actually petition the Constitutional Court to rule on whether, the Contempt Court, in terms of the laws of Uganda, unduly restrict freedom of expression. And this could lead to landmark legal reforms, perhaps, talk about what happened to the Kizza Besigye case. Not really Kizza Besigye, but in light of the issue of the court martial that has actually opened up a Pandora box in light of redresses, or even recommendations, or even other things in light of the UPDFR, for example. He could also apply for bail or even sentence suspension, for example. He can actually apply for bail pending appeal to request the court to suspend the sentence until the appeal is actually dismissed, or even determined, for example. And that is something that perhaps you could also look at as a recourse in light of the challenge that has befallen His Excellency, the President of the Law Society, as we speak today. Now, he could also engage in civil and even human rights advocacy, for example. Ssemakadde is actually known for his outspoken activism and may actually, leverage this moment to spark legal discourse on judicial accountability and free speech and even legal reform. And that is substantially important for him, perhaps to look at as well in light of the challenge that has befallen His Excellency, the President of the Law Society, as we speak today. In light of the impact on Uganda Law Society, for example, we could argue in terms of institutional crisis and leadership void, which is substantially another aspect that's likely to come. Yeah, the imprisonment of its president places the Uganda Law Society, for example, in a constitutional dilemma regarding leadership in terms of succession, for example. And the society must clarify whether Ssemakadde remains in office while appealing, or if he is temporarily replaced, and that has to be a question of their mandate as well, in light of following the regulations or the laws as the law gives them that mandate. And then the aspect of pressuring to defend the legal fraternity, for example. The Uganda Law Society is now under pressure to take a strong stance in terms of either defending Ssemakadde's right to free speech, or even siding with the judiciary's need to maintain respect for the courts. And their response obviously will shape public perception in terms of Uganda Law Society's independence as well. And that is substantially important, because again, Uganda Law Society has to be seen to be independent for it to act or carry out its work. And then the question of the deepening fractures within the legal fraternity also is another question of concern. Yeah, lawyers and judges who support judicial restraint may actually see this as a justified punishment, for disrespecting the courts. So others, particularly those in legal activism, will actually view this as judicial overreach and aimed at, for example, maybe intimidating legal practitioners. I mean, this is not the first time we are seeing such punishment overreaches that are happening to lawyers or people who are acting, perhaps in their own right in light of judicial activism or legal or whatever arguments for that sake. in terms of international and regional implications, for example, international legal organizations such as the East African Law Society and International Bar Association, for example, may condemn the ruling, potentially damaging Uganda's reputation in terms of global legal circles. And that is something, again, that we have to contextualize in light of what has just happened to His Excellency, the President of the Law Society. And the critical moment, obviously, for Uganda, in terms of Uganda's legal system, the imprisonment of a sitting president raises fundamental questions about judicial independence, and that is something, again, you cannot iterate. It also, raises issues in terms of freedom of expression, while it also limits, and also in terms of the limits of the concept of laws. Ssemakadde's next step, whether appealing or petitioning for constitutional review or rallying legal activism, will depend on the future trajectory of judicial accountability in terms of Uganda, and that is something, again, we have to contextualize in as far as this issue is concerned. Now, for the Uganda Law Society, this moment demands strong institutional leadership to ensure that the legal profession remains both respected and free to critique the judiciary without fear of persecution, and that is something that is super important. Yes, and also, the question, obviously, is the incarceration of Uganda Law Society President Ssemakadde justiciable? The argument of whether or not it's actually justiciable. The question of whether the imprisonment of Ssemakadde is legally justiciable, meaning whether it can actually be properly examined or even challenged or even overturned, by a legal process, requires an analysis of concept of court laws and also constitutional rights and even procedural fairness, if you like. And these are substantially things that are going to come up in light of judicial in terms of jurisprudence for that case. So the legal basis in terms of the content of court in Uganda, for example, has to be argued and contextualized in the sense that the content of court is recognized in Uganda as an offense aimed at protecting the dignity and authority of the judiciary, and courts have inherent powers to punish conduct under of course under the Judicial Act, no doubt about that, but also under several other provisions. For example, if you look at Article 128, Sub-Article 3 of the Constitution of Uganda, which affirms the independence of the judiciary and prohibits interference with court proceedings, becomes super important for us to comprehend here and contextualize in light of what we're talking about. And if you argue in terms of common law precedents also allow courts to act against those who undermine the authority. Yes, and that is substantially important, again, from the word go. So all these create a basis under which Ssemakadde defines the situation. However, while contempt laws serve as a legitimate function, they must be balanced against constitutional freedoms, particularly the following, and this is where you must understand the debate. Look at Article 29, Sub-Article 1A of the Constitution, which guarantees freedom of speech, including the right to critique public institutions. That cannot be negated away. That cannot be done away. Look at Article 44C, which prohibits derogation from a right to a fair hearing, meaning an accused person in contempt proceedings must be given adequate defense as far as their rights are concerned. And that is substantially important, again, from the word go, regardless of how the position plays. And we could also ask quick questions. Was the incarceration, for example, of Ssemakadde justiciable? We need to question this. We need to ask these questions all of ourselves. And in doing so, we have to ask certain fundamental questions. Was due process, for example, followed in convicting him? Yes. And that is fundamentally important in terms of contextualizing our debate again. And then, does the sentence, for example, align with the principles of justice in terms of proportionality? That is, again, substantially important in terms of how we are going now placing the issue. We are now dissecting jurisprudence in light of this. And then, does contempt of law, of constitutional rights, such as free speech, that is another super important question that we need to question ourselves. I don't know what we're going to do for this country, but gone are the times where we begin to take the law in our whims and begin to argue at the dispensation of our own desires. The Constitution must be the fundamental guide of everything that we do. And I know that Constitution can mean different things to different people. But if you're arguing in terms of legal arguments, in terms of his imprisonment, it is not just searable, and I would argue it's legal flawedness in terms of a violation of freedom of speech, for example. Courts must balance contempt powers with fundamental freedoms. The African Commission on Human Rights, and people's rights has actually emphasized that public, officials, including judges, must be open to criticism. Look at the case of media rights agenda versus Nigeria. Yeah, it lays that fundamentally well. Ssemakadde was punished merely for expressing a legal opinion or criticism for judicial ruling. Yeah, and his imprisonment contravenes, free speech protections under Ugandan international law, regardless of whatever word he may have used. We are the lawyers. We should be the custodians of language, not so. At least according to what Lord Denning. Yeah, the lawyer's tool is the tongue and the pen. And we should have that connotation and appreciation of English. Yeah, and then look at the abuse in terms of judicial discretion. Contempt should be used sparingly, and sentencing should be proportionate. Yeah, a 2-year imprisonment for a social media remark is, in my opinion, excessive and raises concerns about whether the court misused its powers. Yes, in Attorney General, for example, versus the Monitor, the Supreme Court of Uganda ruled that judicial discretion must be used to suppress legitimate criticism of public officials. That, my friend, becomes super important. Now, let's argue in light of what we call maybe lack of fair trial principles. Yes, contempt proceedings must adhere to fair hearing rights. So if Ssemakadde was actually denied an opportunity to adequately defend himself or present, mitigating factors, then obviously that violates Article 28 of the Constitution, which guarantees the right to fair trial. And that is something you must comprehend again from the word go, whether you like it or not. Now, fair contempt also in processes require clarity on what constitutes contempt, whether warnings were given, whether alternative sanctions such as fines were actually considered before resorting to imprisonment. Did we explore some of those options, or did we just give a sweeping statement because we wanted to bite hard? The Baganda have a saying, Womega, Woluma, Womega Toluma. That's argument. Let's be realistic. Let's apply Ubuntu in spite of how hurting these issues may be. In terms of legal arguments that his imprisonment is actually justiciable, whether or not it's legally sound, can we argue in light of the protection of judicial authority? Yes, we could argue and say courts worldwide, yes, punish contempt to maintain order and integrity. Without such powers, obviously, the judiciary could actually, face uncontrolled public attacks, eroding confidence in terms of the legal system. I cannot deny that. Even when you argue in light of the case of Ray versus Gray, the UK courts uphold or even upheld the contempt, penalties of scandalizing the judiciary, arguing that courts must actually be shielded from undue public influence. And I agree with that. But you see, the point is, when you're arguing in terms of precedents for punishing lawyers who undermine the judiciary, then it becomes dicey in how you should actually decipher or how should play out your issues. Legal professionals are held with high ethical standards. Yes, and under Rule 13, for example, of the Advocates Profession Conduct Regulations, lawyers must respect the courts and avoid conduct that brings the judiciary into disrepute. I have no doubt and no quarrel with that. Now, the point obviously here is that if Ssemakadde's statements cross the line into, for example, defamatory or even inflammatory attacks, then the court you could argue, was justified in taking action to protect the judicial integrity. Yes, but that's a question of debate, notwithstanding what I've just said in light of how about other options. And then the aspect of no immunity. The law applies equally to all. Being a ULS president, obviously does grant immunity from judicial discipline. No, not so. In Rimu Lira, for example, which was a Ugandan case way back in 1967, a Ugandan lawyer was actually convicted of contempt after making disparaging comments about judges, reinforcing the principle that no individual is actually above the law. And these are substantially important aspects to argue even in terms of what we're talking about today. So even as we argue, we have to be mindful of the fact that in the imprisonment of Ssemakadde, whether or not it's justifiable in light of sound jurisprudence, is based on the analysis that I gave, and can be challenged in terms of the argument of imprisonment, or whether or in terms of constitutional or even procedural grounds, in terms of whether or not they are stronger in light of the justification that I've just argued, and why his imprisonment should actually be challenged if it appears to violate the freedom of speech or protections by minimizing judicial criticism, for example. And these are fundamental aspects that we have to bring to bear when we are arguing this particular context in terms of the debate today. Yeah, so the punishment, in my opinion, may be excessive, given that alternative warnings or even fines or even professional reprimand were actually viable, regardless of the individual we're all talking about. Yes, those, in my opinion, could actually be alternatives. So my point is that it could actually set a dangerous precedent in terms of selecting legal professionals who challenge the judiciary. Yeah, I mean, we've seen that with what? With Mabirizi. And then we see so we are looking at this as a question. Perhaps, I mean, the question is what comes next, and who is next after this? What are we going to do? What are we going to do? How are we going to argue in terms of that? So the point of the point in light of my brother and distinguished friend, the appeal for judicial review, Ssemakadde could actually challenge the conviction, the Court of Appeal, or even the Supreme Court, to clarify the limits of judicial power in terms of these contempt cases. Yes, and then in terms of what? In terms of petitioning the Constitutional Court for a constitutional challenge could actually lead to a landmark ruling in terms of the balancing between judicial respect and aspect of free speech. That could also be something that he could explore. And then, and obviously, in terms of a call for legal reforms, I mean, this case would definitely highlight the need for clear guidelines on contempt law, ensuring that that punishment aligns with constitutional rights, rather than sometimes high-handed decisions, or even very, 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 very hard recourse in terms of that. As a question of final thought, I would argue that while courts must actually safeguard the authority, they must not use contempt laws as a shield against accountability. Yes, Ssemakadde's case, in my opinion, presents an opportunity to redefine the boundaries between judicial discipline and freedom of expression in Uganda's system. My friends, my name is Azza Christopher Lubogo. Find most of our books at lubogo.org and suegenerationlawapp.com. God bless you, and I pray that the Lord blesses, guides, and gives us redress in this dilemma that we're facing today. God bless you.